Welcome back to the Constitutional Clarion. Someone forwarded to me a link to an Auslaw Reddit where a Redditor hoped that I would do a video on the question of whether a state governor could refuse to issue Senate election writs. A very good question, I thought, so this video is your answer. First, as always, a little bit of background, this time as to why the states are involved at all in Senate elections. At the time the Commonwealth Constitution was being drafted in Australia in the 1890s, the United States Senate was comprised of 2 senators from each state chosen by the legislature of that state, not the people. Now, this was later changed by the 17th Amendment to the US Constitution, which was ratified in 1913. But in Australia, back in 1891, when the first draft of the Constitution was being prepared, the framers did draw quite a lot upon the US Constitution. So they picked up the US approach and provided that the Senate in Australia shall be composed of 8 members for each state, directly chosen by the Houses of the Parliament of the several states. Now, that was changed in Australia at the next session to draft the Constitution in 1897 to allow instead for the direct election of senators by the people of the state. Nonetheless, the other provisions in the draft Constitution concerning the role of the state in relation to the choice of its senators remained. This includes Section 9 of the Commonwealth Constitution, which, among other things, confers upon the Parliament of a state, not the Commonwealth, the power to make laws for determining the times and places of election of the senators for that state. For example, in New South Wales, there's a Senators Election Act 1903, which deals with matters such as the dates of nomination and polling, what is specified in the writ for Senate elections, the places and hours of polling, etc. There's also a rather handy provision in Section 9 of that State Act, which allows the state governor to provide for extending the time for the holding of the election or the return of the writ to meet any difficulty which might otherwise involve interference with the course of the election. Now, going back to the Commonwealth Constitution, Section 12 says the governor of any state may cause writs to be issued for election of senators for the state. Now, the term here, governor, also, according to Section 110 of the Constitution, extends to whoever happens to be administering the state at that time. So it could be the governor, it could be the lieutenant governor, or it could be an administrator. Section 12 doesn't provide any further direction as to the basis upon which the state governor, lieutenant governor or administrator, acts, or how this is coordinated between the Commonwealth and the states. The only condition imposed concerns the dissolution of the Senate, which is what occurs when there's a double dissolution under Section 57 of the Constitution due to a deadlock between the houses, and it's relatively rare. In that case, Section 12 says, in case of the dissolution of the Senate, the writs shall be issued within 10 days from the proclamation of such dissolution. There are other timing constraints, however, in relation to half Senate elections, which are the normal Senate elections that we have. The terms of half the senators will become vacant on the 30th of June this year. Section 13 of the Constitution says that the election to fill those places has to happen in the year before those places become vacant. It also says that the term of a senator begins on the first day of July following the day of the senator's election. And this is why people often say, well, at the moment they're saying 17th of May would have been the last day for the holding of the Senate election, because they need enough time after polling day in order to engage in all the counting and the recounting, etc., so that the writs can be returned and the outcome of the election can be certified by the state governor to the Governor-General before 30th of June, so that the election is complete, so that the elected person's term can then start on the following 1st of July. If the election went any longer than that, if it went past 30th of June, then the next 1st of July would be a year away. And that, of course, would mean that you'd end up with a state with half its representatives not being in the parliament for a year, which would not be very good. So these are the timing constraints that also affect what state governors do in relation to the issue of the writs for the half-Senate election. So regardless of any advice that is given to the state governors, they would, in order to comply with the Constitution, need to ensure that the writs were issued so that an election could be held on a date with sufficient time for the election to be complete before the 30th of June. Now, the harder question is, who advises the governor in relation to the issue of the writ? Is the state governor acting as a Commonwealth official advised by Commonwealth ministers in issuing the writ, or is the state governor advised by state ministers, or does he or she have a personal discretion? This question was addressed quite early by the High Court in a case called the Crown against the Governor of South Australia in 1907. And the High Court held that the governor, when issuing an election writ for a half-Senate election, is acting as the vice-regal officer of the state, not as a Commonwealth official. It had been argued that the governor was appointed under the Constitution to fulfil this function in his or her own personal capacity. But the High Court disagreed. It concluded that the governor was acting in his state capacity in relation to the issue of the writ for a Senate election and was not subject to an order of mandamus by the court, which is an order that would compel the state governor to act. The governor could not be commanded by a court to do an act which only the Executive Council of the state could advise him to do. Justice Barton, who's that Edmund Barton, who was the first Prime Minister of Australia and also one of the key framers of the Constitution, so after he'd become a High Court judge, Justice Barton explained that this was a duty of imperfect obligation. What does that mean? Well, it means it's a duty to comply with the Constitution, but a duty that is not legally enforceable. So it's this type of political duty or a moral duty to comply with the Constitution, even though you can't be compelled by a court to do so. Equally, the state governor could not be compelled by the Commonwealth government to issue a writ. In practice, the Governor-General writes to the state governor setting out the relevant dates for the proposed Commonwealth election and requests or invites the state governor to issue the writs in accordance with those dates. So here's the Prime Minister's letter from 2025 to the Governor-General asking that she propose that the relevant dates be adopted by the governors for the half-Senate election. And also, here is the Governor-General's reply saying that she would do so and invite the state governors to issue the writs. Once that letter is received, the state governor then alerts the Premier's department of the relevant state and arrangements are made for giving formal state ministerial advice to the governor to issue the writ. If you look at a Senate election writ, and because at the time I'm recording this, the ones for the 2025 election haven't been made yet, but let's look at the New South Wales one for the 2022 half-Senate election. You'll see that it's signed by the governor, in this case Margaret Beazley, and countersigned by the Premier, who was Dom Perrottet. Here is also a photo of the Western Australian Governor, Kim Beazley, at the Executive Council meeting, which advised him to issue the writ for the 2022 half-Senate election in relation to Western Australia. And as you can see by the masks that they're all wearing, that this was during the time of COVID-19. But could a governor, acting on the advice of state ministers, issue a half-Senate writ contrary to the wishes of the Commonwealth government about its timing? Well, I've already done a video on that. The example is on the night of the long prawns. So have a look for that video. If I remember, I'll put a link to it in the description beneath, in the box beneath this video, because it's an absolute hoot. It is a great story about attempts to manipulate the half-Senate election by the timing of the writ by both the Whitlam and Bjelke-Petersen governments. But there's also another quite interesting story about election writs, also from the Whitlam era. In the lead-up to the dismissal of the Whitlam government in November 1975, the National Times newspaper reported that Whitlam was considering holding a half-Senate election, but that the premiers of New South Wales and Queensland might advise their state governors not to issue the writs for it. Now, perhaps as a result of political wargaming at the Commonwealth level and consequential leaks to journalists, the newspaper also reported that in such a case, Whitlam intended to advise the Queen to instruct state governors to issue the writs against the advice of their premiers. From a constitutional point of view, this would have been highly problematic. While Whitlam could advise the Queen as Queen of Australia in relation to federal matters, he had no power to advise the Queen in relation to Australian state matters. At that stage, as bizarre as it may seem today, the Australian state still came under the British Crown, so that when the Queen exercised her powers in relation to the Australian states, she did so under the separate hat, or crown, as the case may be, of Queen of the United Kingdom, not as Queen of Australia. And the consequence of that was that she was advised by British ministers in relation to the exercise of those powers, not Australian ministers. Now, Whitlam, throughout his time in office, had tried to break that connection between the Australian states and the British Crown, but had failed to do so. When British ministers were alerted to the prospect of such advice to the Queen, potentially from Whitlam, they became quite concerned. While they were satisfied from a constitutional point of view that Whitlam could not validly advise the Queen of Australia to then get the Queen of the United Kingdom to instruct the Australian state governors to defy the advice of their responsible ministers at the state level, they really didn't want the Queen to be dragged into such a controversy. Apart from anything else, the niceties of those constitutional distinctions would be completely incomprehensible to most members of the public, so there would have been a huge hullabaloo about it. In October 1975, Sir Michael Palliser, who was a senior official in the Foreign Office, arrived in Australia on a routine visit. One of the meetings that he held was with the New South Wales Governor, Sir Roden Cutler. Palliser's account of the meeting is as follows. It's quite a long quote, but here it goes. Cutler was very concerned at the present political crisis because he could see at present no room for compromise. We are dealing with two very pig-headed men. He feared a confrontation. The outcome was unpredictable. He was critical of Fraser. One could sympathise with the opposition in the light of the behaviour of ministers, but he believed Fraser had chosen the wrong battleground. Things could recoil on him. He believed public opinion would tend to move against the opposition's stand. At this stage, the quote becomes quite awkwardly worded, so I'm just going to move around a couple of bits to make it make a little bit more sense. If state governors refused, on the advice of their own premiers, as Cutler himself would, to call a half-Senate election, then there was a risk of the Governor-General acceding to a request by Whitlam to ask the Queen to instruct the governors to call an election. Following on with the rest of the quote, Cutler said, and here's the message, that if that happened, he would feel obliged to resign. But he went on to say that he was sure the Governor-General knew, as well as he, that neither the Queen nor Her Majesty's government wanted to get involved in this essentially Australian dispute. He was reasonably confident that the Governor-General would therefore not act in the way he had described. End of quote. Palliser went on to say that there was nothing else of note with which to take up the time of the Foreign and Commonwealth Office. It's quite clear that this was the constitutional crisis that the British anticipated might arise, and that the dismissal of the Whitlam government wasn't actually on their radar. The message from Cutler was that if he was advised by his Premier not to issue the writs, then he would act on his Premier's advice and he would not issue them. And if he then got an instruction from the Queen to act contrary to his Premier's advice, he would resign. Now, this would have magnified any constitutional crisis. It's unlikely that any other person who was appointed as governor would have been prepared in the circumstances to act contrary to the Premier's ministerial advice either. The British government's legal advice in relation to the issue of the election writs was that the state governors would not be exercising federal functions in deciding whether to issue the writs and would therefore have to act upon the advice of state premiers. They concluded that Whitlam would have no power to advise the Queen about how a governor acted to fulfil state functions. The British Foreign and Commonwealth Office assessed the risk of being drawn into the dispute as follows. It is remotely possible that UK ministers might be placed in an awkward dilemma over the matter of half-Senate election writs if Sir John Kerr were persuaded to ask Her Majesty to intervene, but did so on grounds of doubtful legality, and the palace then sought advice from UK ministers on the matter. Fortunately, that seems most unlikely, not only because Sir John Kerr is himself a distinguished lawyer, but also because Mr. Whitlam's legal advisers would surely be able to succeed in dissuading him from such action when the constitutional position was not sufficiently clear-cut as to justify drawing Her Majesty into a political controversy. The British Foreign Office then thanked the British High Commissioner in Australia for his report on the meeting between Sir Michael Palliser and Sir Roden Cutler and concluded by saying this: "This provided most useful and comforting confirmation of the view we had already expressed in submissions to ministers that Sir John Kerr could be relied upon to resist any precipitant action which might involve either Her Majesty the Queen or Her Majesty's government in what is, essentially, an Australian domestic dispute." The advice given to the relevant ministers in the UK was that because the question of British involvement in relation to the issue of the writs was merely hypothetical, and it was improbable that Sir John Kerr would let Whitlam draw the Queen into the matter, it was best that no action be taken. If any attempt were made to get in touch with Sir John Kerr, they thought, for the purpose of asking him to keep the Queen out of the matter, quote, "Such advice could well offend the Governor-General, who might feel that he was being told how to advise on a matter for which he is already well qualified, while Mr. Whitlam, if he heard of it, would inevitably suspect the UK's involvement," unquote. So the British government decided to, quote, "do nothing," unquote, except to continue to watch developments carefully. As it turned out, Whitlam did seek to advise the Governor-General to hold a half-Senate election, but at that very moment, he was then dismissed before any question actually arose of whether state governors would issue the writs. Since then, the Australia Acts 1986 cut off that relationship between the Australian states and the British government, so that they would no longer be involved in such an issue. But the same jurisdictional problems would still arise. This is because Section 7 of the Australia Acts makes most of the monarch's powers with respect to a state exercisable only by the state governor. It also provides that any advice to the monarch on the exercise of his or her remaining powers with respect to a state shall be tendered by the Premier of the state. So if a state Premier advised the Governor not to issue the writs for a half-Senate election, we know three things. First, neither the courts nor the Commonwealth could instruct the Governor to issue the writs. Second, the monarch could not exercise any power to instruct the state governor on the advice of the Prime Minister. Only the state Premier could give such advice to the monarch. Third, the Governor is under a constitutional duty to issue the writs in time for vacant Senate seats to be filled. While this duty is not legally enforceable because it's a duty of imperfect obligation, a Governor may feel obliged to comply with the Constitution and issue the writs at the last available time, even without advice from state ministers, on the basis that the rule of law means that the law and the Constitution apply to everyone, including the Governor. So the Governor must obey the Constitution. Fortunately, no state governor has ever encountered such a dilemma, and hopefully it will never happen. In practice, if such a situation was looming on the horizon, a capable governor would use his or her right to counsel and to warn as a means of preempting or resolving any such crisis before it ever came to pass. Thank you once again for watching the Constitutional Clarion. I hope you found this interesting. And as always, I look forward to seeing you again next time. Goodbye.